Welcome to this module. I start with an introduction of Mr. O.P. Gupta. Mr. O.P. Gupta is the Controller General of Patents, Designs, Trademarks and Geographical Indications of India. It is a very important position. He is basically the key nodal point for all the intellectual property filings that is happening in India. And as you know, India is a major country in so far as intellectual property rights are concerned. Mr. Gupta is an officer of the Indian Administrative Service, quite a senior officer, over 25 years of experience. He was allotted to the Maharashtra cadre, occupied senior positions in Maharashtra cadre of the Indian Administrative Service before moving over to the position that he occupies today in the Patent, Trademark and Designs and Geographic Indications Office. In the past 2 years, Mr. Gupta has presided over very fundamental changes in the IP environment in India, and we are here to hear from him on what his experiences are, what his views are on how to be process forward. So, I start welcome Mr. Gupta to this program. We have been focusing on this program very intensely to provide a module on IP management for managers, and it has a fundamental reach not only in India, but also across the world. So, let me explore with you your experiences with intellectual property management in India. In the past 2 years, we hear great stories about how the IP environment in India has changed. What do you think are the big changes that have happened, and what do you think are the directions in which we are moving as far as intellectual property is concerned?
Thank you, Professor. First of all, I congratulate I am Bangalore for this module preparation, because as we all know, IP intellectual property is becoming a very important tool in an overall development process what the government is looking at. You know, post India joining TRIPS agreement, Indian IP laws were restructured and brought in line with the international IP regime, and in 2005 India's integration with the world IP regime was complete. So, all Indian laws, including Indian Patent Act, the Trademark Act and GI as well as Design Act, they were suitably amended to incorporate and bring them in line with the international obligations which India willingly accepted as part of the TRIPS agreement. Subsequent to that, the filings in Indian IP offices by international applicants and Indian applicants both increased multifold. If we look at, say around 2005, average filings in India used to be something in the range of 8-10,000, which reached 46,000 by the year 2014-15, and similar is the case in terms of trademark filing, design filings also. Now, with increased number of filings, somehow during the early years, the commensurate increase in the manpower and systematic systems and procedures for processing these applications couldn't take place, which actually resulted in lots of pendencies being built up in Indian IP processing systems, and therefore, in patent and trademark we had lots of pendencies which were affecting quick recognition of IP rights of its creators. The Indian government took a serious note of this issue, and since around 2007-8, the intellectual property office modernization project was actually launched in India, what we call MSIPO. The three main component of that project was the human resource enhancement, creation of IP office infrastructure for suitably accommodating the incremental manpower, and creating a robust IT system and platform for processing of these applications, so that
for rapid processing.
Rapid processing for in terms of IT, but second is that the data, because in intellectual property the data is also as important. Now, digitization of data is an important aspect for quick search and quick retrieval of the information related to the earlier applications and exchange of information with other offices. So, all these things started, and they actually culminated in a way by promulgation of Indian intellectual national IP policy in May 2016. So, that has been the step by step process. Now, when we talk about last 2 years, actually the enhancement of manpower finally we could induct in terms of patent was last year, when we recruited 450 plus examiners in addition to the existing 130 which only we had. So, you can imagine that from 130 existing examiners, the examiners
strength, very drastic increase in strength,
increased by 450.
So that is a major change.
Yeah, that is a major change, because after training of these examiners, when they started examination work in substantive examination system, Indian applications now being examined in Indian Patent Office has increased on an average from 1500 to 4500. We get around 3500 requests for examinations on an average per month, and we now consistently examining more than 4500 applications per month, which has started bringing down the pendencies which had been built up over the years. And we are very hopeful that in patent examination we will bring down these pendencies to internationally accepted levels within the next 2 to 3 years. In trademark, again we did, apart from enhancement of manpower, basic systematic improvements in procedure we undertook, and that has resulted in bringing down pendency in trademark examination process from 14 months to less than a month. Now, Indian trademark registry examine all new applications within 30 days of the receipt, and if there are no objections and no oppositions, we actually deliver the registered trademark certificate through e-mail of that applicant within less than 7 months.
In fact, I should tell you that I have a trademark registered, and I was quite surprised to see the quickness with which I got it. Got what I had to get. There was one claim of mine which was not accepted, which means that the trademark office, your office had taken a very close look at it and said that, well, this is something which we are not going to accept, this claim is accepted. So, I can bear with this statement of yours, because it comes from my own experience.
Yeah.
Trademarks has been trademarks because I only file trademarks. So,
now, for Indian system, luckily trademark is from day to day need for regular traders and manufacturers and the people who want to do trade in their goods and services, and number of trademark applications filed in India is one of the highest in the world. Around 300,000 applications per year we are receiving for last 2-3 years. Then design is another aspect where registration of new designs is also as important, because in India lots of creativity in terms of clothing and in terms of various other artifacts, where people do want to register their designs as well. There also now design pendencies has also been brought down to less than 1 month, and we are now moving to the next stage, where the subsequent processing of those applications which had been objected to and which has been replied to by the applicant are also processed in quick time. Geographical indications for India is an important aspect, because India being have this very rich cultural and natural heritage provides that kind of opportunity where lots of local community knowledge is there for ages, and Indian nature being so diverse from north to south and east to west, that natural products in India, whether they are agriculture produce or whether they are actually in terms of nature's product in terms of stones or certain other things, they also have lots of unique qualities, and quick recognition of all that heritage by way of GI is as important. So, all these systems are being strengthened to make sure that Indian IP regime in terms of recognition of the intellectual property right of individuals, of business as well as of community are done in quick time.
That is very good to hear. The other thing that I wanted to know specifically is, we will go back to patents. What do you think is the time for getting a patent from the date of application, and assuming that you are not going to have any pre-grant opposition, what is the average time that is taken these days?
That time is still, I will say, for the current applications which we are examining, it is around 7 years.
7 years
as of now.
Okay.
But as I just indicated, with now increased number of examiners already in place and increased number of controllers in place, this processing is being increased almost at twice the number of applications filed in a month. Okay. And within next 2-3 years, we plan to bring it down to less than 3 years across the board for all applications in patent.
Oh, that is very good. It sounds very encouraging. The other question was about geographical indications, about which you mentioned that India is very rich in geographical indications, and there is an indication that you are flooded with applications. Is it true, or
I will say that we do have reasonable number of applications. In fact, over the years, last few years, we have received around 550 plus applications as of now, out of which around 275 applications have been finally processed and GIs have been recognized, and other applications are now in process. So, I will say now new application filings have come down around 25 to 40 per year.
So, what is the total stock of GIs that we have? I mean, how many GIs we would have recognized since the GI Act came into being in 1999, right?
Yeah. As I said just now, that around 275 GIs are already recognized and in place, which includes agriculture products such as Darjeeling tea and various varieties of rice, mangoes, chilies, such other things, lots of handicrafts and manufacturing goods, including say Puneri Pagdi and Patni Sari and Kolhapuri Chappal to Muradabad brass work, or some Dokra work in Bihar or Chhattisgarh or Jharkhand. In Banaras, lots of handicraft items from there also are recognized as GI. Lots of northeast products, they are on the list of GIs which have already been recognized.
So, in many ways it mirrors our cultural diversity. Your office also gets a great idea about the spectrum of cultural diversity.
Yes, as I said,
in terms of, as you mentioned very rightly, that is interesting. The other issue which keeps cropping up in the media is about China being ahead of us when it comes to patents. What could be the reason? Have you looked at why is China ahead of India when it comes to patent filings?
See, China, there are two things. Of course, China started much earlier than India in terms of probably moving in the technological space, and that is why China in fact is kind of manufacturing factory for lots of things. Now, since they got that early mover advantage in terms of manufacturing, which normally always involve patent for processes as well as products both. China and Chinese industry did have a big headway on India in that terms. Second, I suppose the research and development expenditure and maybe the university system in China is little larger than as compared to India, which also helps them create and move for new items and new products and processes which they need patenting for. Obviously, China in terms of economy scale is much larger than Indian economy, which automatically will mean that lots of economic activity in terms of development in industry, in research and development and in other areas, which automatically will
reflect on the
reflect in terms of intellectual property.
But you are confident that India will be catching up with this big corpus of examiners coming in. It should make a difference in terms of not only the backlogs, but also creating a hope that if I file a patent application, I am going to get it faster, and therefore it is worthwhile.
Sure. In fact, that's what I am saying, that within next 3 years we should bring down our overall patent examination and grant processes to almost at par with China or US. That should be around 3.5 years, because currently all these countries, there also it takes around 32 to 36 months to get a patent granted. That includes around 24 to 26 months of examination time and 8-10 months subsequently. In India, we plan to achieve that kind of timelines within next 3 years for sure. We will certainly try and reach early, but within next 3 years I am absolutely sure that our timelines will be within 3 years of filing of applications for patent being fully processed and finalized. Now, that being one aspect where we provide the quick processing part of it, filing in India even today, yes, it lags behind in terms of national filings, what we call filings by the Indian applicants. Even today, it is around 30% of the total applications filed in Indian Patent Office, which has grown up from 22% to 30% of total applications within last 3-4 years, but it is still on a much lower side when you compare say China, where almost 80% applications are filed by national applicants, which in my opinion is reflective of either the research and development expenditure in the industry itself. That is one possibility. Second, various multinational companies setting up research and development facilities in India, which currently lots of them are there in China, but as we improve our infrastructure, as we get more and more technical and trained manpower, I am sure lots of such facilities will move to India, and that is one of the major programs I suppose on the government agenda, and one of the major objective of the Indian national IP policy, creation of more IPs as part of the IP policy, where research and development expenditure is also enhanced, facilities are created. Then Indian universities taking proactive efforts and providing that facility for Indian research students, which currently probably go out a lot and do research in foreign universities, that kind of research moving to Indian universities, whether it is technical universities or whether it is other fields, that I suppose will be the key as to how quickly we improve the filings from Indian nationals in India.
So, what do you think would be the big challenge in terms of awareness on IP? Do you think under the national intellectual property policy, there is a very strong emphasis on awareness, which needs to be translated to very concrete programs. Do you think IP office has the mandate to increase awareness, or you think that these should be done by other agencies? What is your view on this?
See, national IP policy, in fact, if you see the objectives, out of 7 objectives, the first one is awareness and making people really understand the intellectual property. And for that, within the ministry, a separate cell has already been created, which is cell for
the Department of Industrial Policy
in
and
DIPP.
Promotion.
This is a cell for intellectual property promotion and management, what we call CPAM. And this cell is basically created for taking care of 3 objectives of this policy. One is, of course, awareness program, second is commercialization of intellectual property in India, and third is enforcement. Now, awareness programs, CPAM has already planned more than 4,000 awareness programs for the current year, which the IP office has been doing for all these years. We continue to undertake those programs, and we have also increased the scope of those programs in terms of what earlier we were doing most of these programs in association with various industry bodies like CII or ASSOCHAM or FICCI, and some national and national universities or national institutes like NRDC and various universities. But now we have moved to even schools. So, even in the current year we have planned that we will do around 200 programs with various schools, where the schools children are sensitized and they are given their first lesson in terms of intellectual property. Why I feel that is important? Because when we grew up, we never really knew what is intellectual property. We always thought the movies and songs are always there to listen and to see, without knowing that there is some kind of intellectual property involved in this. Now, these are the things. CPAM also is already coordinating with various school boards, CBSCs and ICSCs, and we are trying to now see that some part of IP gets into curriculum in the school and colleges. That is one. Second, enforcement agencies, because awareness is one aspect, but enforcement is an equally important aspect to spread awareness of intellectual property, because people knowingly or unknowingly, either themselves or through somebody else, end up infringing and violating intellectual property rights. Now, lots of people do it unknowingly, and they really do not derive commercial benefits out of it. Actually, at times they may be losing value and money on buying those fake products. So, enforcement is also an important aspect, and CPAM and our office is now taking programs with various enforcement agencies. In fact, recently in Delhi, a 3-day national workshop on enforcement was organized for all state and national agencies, which was inaugurated by the Home Minister of India. And the Honorable Home Minister actually in that workshop has kind of indicated that intellectual property and its enforcement now will be included in the training curriculum of various enforcement agencies. So, these are the steps which are being taken to not only spread awareness, but also give emphasis on enforcement of intellectual property.
Okay. That sounds very promising actually. The issue of quality of IPRs is engaging the attention of the world community. For instance, WIPO talks about it, and you yourself have mentioned how important it is to have a qualitative improvement in examination and grant and all that. How do you think quality of patents and designs can be enforced in India, given the kind of expansion that we are talking of?
I will say that quality of patents being granted in India is probably one of the best as of now.
Okay.
Why I say so, that when you talk about quality, a patent does affect interest of lots of other parties, and therefore Indian law has provisions what we call pre-grant opposition and even post-grant opposition. So, the number of opposition which gets filed in India is one aspect, but subsequent to the grant people have opportunity to challenge the grant in court of law if their rights are affected, and if they feel that a wrong patent has been granted which is affecting their own rights. So, when we look at the legal challenges to the patents granted in India, we will find that that number is very minuscule, in fact less than 1%. And wherever these challenges have taken place, most of the decisions of the patent office have been upheld by higher courts, either in terms of grant or in terms of denial. As against we see some of the developed economies, patent revocation percentage is very as high as 7 out of 10 patents being challenged, especially in fields like computers and IT. Now, 7 patent revocation out of 10 being challenged is really a qualitative issue as compared to, I will say for India 1 or 2 maybe in 100. So, and this is when we talk about that challenging a patent grant in India is certainly not costly, because in India you can file revocation proceedings in Indian courts which cost a minuscule as compared to something around $400,000-500,000 in certain developed economies, where if you need to challenge a patent grant, it is really costly.
And yet they challenge in large
and
numbers.
Yet because the value involved is such, where the infringing party and the
stands
patent
to gain
holder
or lose.
they feel that much value is there in that suite.
The other issue that has been discussed is the importance of intellectual property to the STAR programs of the Government of India, particularly Make in India, Startup India and Digital India. Now, in that context, how do you see the Patent Office role in facilitating these programs, which are billed as the big programs or the big ticket programs of the government?
I will say we have a very important role in that.
Yes, sir.
And why I say so, that again I will come back to the national IPR policy. The 7 objectives which are listed, one I said awareness, second is creation of intellectual property, and that is why the slogan of Indian IPR policy is Creative India, Innovative India. All these programs does involve, because these are all new programs in terms of when we talk Make in India or Digital India, all these programs involve for sure Startup India, lots of intellectual property which is going to be there. Our role is to ensure facilitation in terms of not only helping them recognize the intellectual property at an early stage, but also provide that kind of support system where they can nourish it and commercialize it. And therefore, national IP policy has a objective commercialization of intellectual property in India, which is at present at a much lower stage. So, in say Startup India programs, our patent rules and trademark rules, now the government has taken initiative by providing fee benefits, certain fee benefits for filers under Startup India programs. Then in patents we have introduced the process of expedited examination for startups in India, and you will be happy to know that under that process already 18 patents have been granted in less than 1 year.
Oh, that's very.
And there has been a patent grant in 113 days from the date of request for
This
examination.
is for the startup, new ventures and
New ventures and the
and new ideas,
you know,
which are likely
creators
to,
who select India as an international search authority for their patent applications.
Oh, okay.
So, this inclusion of expedited examination in Indian patent rules is basically in a step so as to encourage these young startups and new programs to get their recognition of intellectual property at an early stage, which then they can use to expand their business.
So 113 days is quite a record, and then keeping your quality as well.
Yes, that
is a quite an achievement. What about digital India? For instance, digital India could lead to a number of IPs, because it is such a great prospect that you can have IPs, you can even have patents if it is possible, but by far IPs are on software, and especially the non-embedded software is done through the copyright route. Do you think in the days to come, Digital India will require you to consider more patent applications? I am not talking of embedded, I am talking of the non-embedded ones. Are they going under the floor, and the fundamental technologies are likely to come in for patent examination? What I mean is, if are you going to get more of information technology related new products in the patent window? Do you see that happening with this Digital India initiative?
See, now in Digital India, yes, lots of intellectual property will get created. Whether that property fits in the definition of patents or copyright will of course will have to be examined as those claims are filed for specific intellectual property. I like to highlight here the Indian Patent Act has a very specific provisions, and which are actually in tune with most of the international practices, that software per se is not a patentable item. Algorithms are not a patentable subject matter, which is same in India or Europe or even some other developed countries. So, the contents which get created through Digital India, if it is pure software, then obviously it will fit in the definition of the copyright, and now Copyright Office being transferred to DIPP as per the new IP policy. The processing and Copyright Office has also been streamlined, and if you see in last 6 months of functioning of copyright under the DIPP, the copyright register applications, that is entry in the register of copyright for applications which pendency was up to 16 months, has already come down to 4 months.
Oh, okay.
And within this year, before December end, we plan to make sure that all applications for entry in the register of copyrights are disposed of and taken care of within 30 days from the date of filing. So, we will recognize copyrights as quickly as possible anywhere in the world. So, people who are looking for copyright recognition, that will be provided very quick. For patent, if it is really new technology which qualifies in terms of the patentability subject matter,
and
which
not
the
a
law
simple algorithm, not just a
which the law very clearly provide for, then they can come of either of these two routes if they want quick recognition, either expedited examination route by way of if they are a startup, then they have no problem, or else for their international applications they can choose India as the international search authority. Now, to clarify this aspect as to which is the patentable subject matter or not, we have come up with comprehensive guidelines regarding computer related inventions.
Oh, it is a very recent set of guidelines?
Yes, in fact these guidelines was first put in public domain in 2015. There were certain parties which they say that these guidelines inhibit the open source software part of it, then those guidelines were reconsidered in view of the public comments and the input which we received, and in 2016 second guidelines were brought in. On those, the other side did have objection that it actually talked about a word called novel hardware in terms with software. Now, that word novel is being little not very well defined, created some kind of confusion, and then there were further consultations with both the pros and cons of all that, and now the computer related invention guidelines have been recently repromulgated after considering all these aspects, which have been very well received from all the sides, and everybody now recognizes that these guidelines
will become the
kind of
basis
provide a very clear and unambiguous view as to what is patentable and what is not patentable in Indian Patent Act.
Right.
And therefore, now people can actually immediately understand as to whether their invention will be patentable or whether they should go to copyright it. And I hope that these clarification and this clear guidelines now should encourage lots of intellectual property creation in Digital India platform, which should either get patented or should get copyrighted.
Sounds very good. What do you think would be the roadmap for IP in the next 4-5 years, given this kind of a base that you have set up?
In terms of IP offices, I am sure within the next 4-5 years, Indian IP offices will be almost at par for sure, if not better, than most of the major IP offices across the world, in terms of processing timelines, in terms of quality of intellectual property, which we still say that it is. So, without compromising on quality, the timelines will be brought to the internationally accepted norms which are there as of now. In terms of policy, the government has really taken steps. National IP policy is in place, and in terms of promotion, management and commercialization of intellectual property, steps are being already undertaken. Once the IP office recognizes the intellectual property, then the next step in terms of commercialization and then the making that available to a larger public, the benefits of those inventions, which should then further promote new intellectual property creation. With India's development scenario as envisaged by Niti Aayog or the various international agencies, as to that India is likely to grow between 6.5 or 7.5 or 8% in near future. In that scenario, for 5 years,
the only economy which is going to boom in the next 3 years, critical years.
I am certainly looking forward to that. Indian intellectual property filings will go up substantially, and we are now creating enhancement. What we are doing for clearing the backlog should automatically then start taking care of that increased numbers. Once the backlog is cleared within 3 years, by that time the intellectual property filings will reach to that level, and therefore, we will not be stranded with surplus capacity in terms of processing also. So, this is how we have foreseen and planned for next 3-4 years, and I am sure it will be seen that Indian IP offices by the year 2021 or 2021 are probably as good as anywhere you can see.
The last and final question is about internationalization. I remember very clearly an interesting slideshow. I do not know who it was, but there was a presentation in which they juxtaposed, maybe it was 3 or 4 years ago. So, they juxtaposed the old patent office and the new one, and said this itself is a big change. apparently the old patent office looked very old and the new patent office looked very modern and therefore giving a sign of hopefulness. Now, when it comes to internationalization, it was talked at that point that we have got into the PCT route and we are going to have, this is as far as patents goes, we are going to have a number of PCT applications coming up, not only from within India, but also from abroad. We also have the case of Madrid Protocol, to which we acceded about 2 years ago. And the Madrid Protocol was also intended, the accession was also intended to facilitate international filings. And we also had the famous case of Micromax going for a Madrid registration. What do you think is the prospect as you see for internationalization? By internationalization, I mean the number of PCT applications from within India, not necessarily of overseas companies, but within India, I mean the Indian startups and entrepreneurs, as well as the internationalization of trademarks. What do you see to be the prospect?
To start with, first with patents, you always see very encouraging, you already see very encouraging trend in that regard, that PCT filings in India are increasing almost 30% year on year.
Okay.
Of course, they started with very low base of
that jump
as
is
low as 10 or 20 5 years back. They have already touched around 1,000 last year, and this year we are expecting it to cross 1,000 for sure. So, year on year those numbers are going up. Of course, as I said initially, you first need to have national filings, that number of applications. So, of overall total filing of applications, which was 22% 4-5 years back, it has already come up to 30% of those applications, which in terms of absolute numbers amount to around 14,000 applications last year. Out of those 14,000, 1,000 had gone to PCT route in India, which is 7 to 8% of those applications. As our processing will move faster, new and new applications will start filing in India, then their corresponding PCT applications, in my opinion, are going to increase for sure. And as I am looking at by 2020, when we talk about next 3 years, when our timelines come down to those levels that we are able to process a regular normal Indian applications within less than 3 years of filing, corresponding PCT applications will automatically move much faster in terms of patent. In trademark, Indian brands have now started creating that kind of image. After India considered to Madrid Protocol, the international filings of trademark recognition in India from outside have already substantially gone up. Indian applicants, they are still learning that part, filing through Madrid Protocol, because most of the Indian brands today are who are filing for trademarks either in automobile or in pharmaceuticals, and they have a very specific defined market. So, probably that is one of the reasons as to they are probably filing direct route applications in most of these places. But as Indian manufacturers and Indian producers, they expand their markets, they will find Madrid Protocol as a much easier and much better route to register their trademarks abroad. In India, trademark filings have gone up by leaps and bounds already, which is crossing 300,000 this year for sure. Out of that, even if 5, 8, 10% goes through Madrid Protocol, we are looking at real substantive large numbers in times to come. So, I am hopeful that these as Indian economy grows, as Indian enterprise grows, as Indian industry grows, and they find newer and newer market to expand their business, obviously there will be need to protect their intellectual property, which is already protected in India, and that will automatically result in enhancement of intellectual property filings through Madrid Protocol or through PCT route.
It was a pleasure talking to you, and thanks very much for your time.
Thank you very much.